Good morning, all my lovely friends and colleagues, and very, very warm welcome to you to this February edition of the Family Law Roundup. We are only a week late, and we hope that we can make it worth your while. Today, we have a nice cross section of judgments that we will be working through, which we have prepared, but I look forward to going through everything with all of you fine folks today. It seems everyone can hear me properly, so we are ready to go. Right, first off, the formalities, as you are aware, those who are with us quite frequently. What is Think Legal? It is an initiative that believes that while legal services are for the most part a commercial venture, legal knowledge is a public resource which should be freely available to everybody. Right. For those of you who would like to support Think Legal or stay in the know, please go to thinklegal.co.za. There you can register for our events, join our WhatsApp groups, purchase resources, and or view our past webinars. For those of you who are keen, you are welcome to pick up our optional course pack. If you are not inclined to pick up the course pack, you are still more than welcome to attend today. The course pack is 300 Rand, and for this month, it includes summaries of 26 judgments that we will be working through. It gives you your bundle of judgments and 2 SAAM CPD points. For those of you who would like to pick up the course pack, you are welcome to go to thinklegal.co.za and you will find it in our online store. Right, upcoming trainings, folks. For those of you who need to up your CPDs, we've got drafting for divorce coming up the 9th and the 10th of April 2025. That is running from 5:30 until 8 o'clock each evening. That's drafting for divorce, 850 Rand to attend, and you get 5 SAAM CPD points in that training. We will be looking at the legal side of divorce drafting, as well as the language side of divorce drafting, including the danger of jargon, conciseness, how to use proper grammar, phrasing, etc. in divorce drafting. So that is one I'm really looking forward to presenting on the 9th and the 10th of April. And then once again, we have got Divorce 101, which is going to be running on the 3rd, 4th, and 5th of June this year, 5:30 until 8 every evening, and that gets you 6 SAAM CPD points, and that is essentially a crash course in divorce in South Africa. For registration for these CPD events, please go to thinklegal.co.za. You will find the registration links on our website. Right, as always, Think Legal supported by Lawbox, practice management software, and Familiar Attorneys. I couldn't bring myself to removing our pretty beach photo of Belito, so that's going to stay there for a little while. Right, folks, without further ado, let's go into the Family Law Roundup February 2025, which we are presenting on the 14th of March, not the 7th of March, 2025. Right, let's go into part 1. Part 1, we are going to be dealing with divorce, Hague Convention, maintenance, and mediation. Right, first off, we are going to the South Gauteng High Court in the matter of SJM versus SJK, and that is SAFLI reference ZAGPJ HC 92. The judge is Minard AJ, and the date of judgment is the 7th of February 2025. This is a matter dealing with forfeiture of patrimonial benefits and a partial forfeiture specifically, and how the court calculated the partial forfeiture. In this matter, the parties were married in community of property, plaintiff instituting the divorce and seeking division of the joint estate and 50% of the defendant's pension interest in the GEPF. The defendant instituted a forfeiture claim on the basis that he commenced contributing to his pension fund in 1992 until retirement in 2023, which is approximately 31 years. The plaintiff, having left the matrimonial home in 1998, was only present for 6 years of the contribution. In this judgment, the court looked at Section 9(1) of the Divorce Act, obviously being our enabling principle in the Divorce Act for forfeiture of patrimonial benefits. Looked at Vaker versus Vaker and KT versus MR, which we often see cited in forfeiture matters. In this instance, the divorce was granted, obviously, and a partial forfeiture was granted in that the plaintiff forfeits 80% of her claim to the defendant's pension interest in the GEPF, each party to pay their own costs. Our notable quote comes from paragraph 35 of the judgment, and the court says as follows: while it is so that a marriage in community of property is a universal economic partnership where the assets and liabilities of the parties are merged in a joint estate, Section 9(1) of the Divorce Act contemplates departure from this principle upon the dissolution of a marriage in defined circumstances. In determining whether a benefit will be undue, the court in Vaker also cautioned that the equitable principle of fairness cannot be used to justify an order of forfeiture, as it runs counter to the basic concept of community of property. The court, without defining what an undue benefit would constitute, pointed out, however, that in determining whether it was undue, regard must be had to the three factors set out in Section 9(1) and to which reference has already been made. A nice summary of the Vaker principles related to forfeiture of patrimonial benefits. Next up, folks, we go to GD versus Minister of Home Affairs and others. And this is a very, very interesting judgment from the Eastern Cape High Court in Kibera. Renarsson AJ penning the judgment. And this is the matter of GD versus Minister of Home Affairs as others, as I have mentioned. The judgment was delivered on the 4th of February 2025, and it follows the KG versus Minister judgment, which went all the way to the Constitutional Court regarding the unconstitutionality of Section 7(3) of the Divorce Act to only apply to marriages entered into before 1 November 1984, which has then essentially opened it up to all out and out spouses to institute a Section 7(3) claim regardless of when they were married. This judgment of GD versus Minister of Home Affairs and others follows this judgment and deals with a very interesting topic of pension interests. The applicant in this case sought a declaratory order declaring Section 77C of the Divorce Act unconstitutional and invalid on the basis that it excludes pension interests from the redistribution remedy for marriages concluded out of community of property without accrual. The applicant and her husband were married out and out, and he instituted divorce action against her in 2020. In the amended particulars of claim, the applicant indicated that she would bring forth the present application, declaring Section 77C unconstitutional and invalid, to make sure that the pension interests could form part of the redistribution order. The court looked at several interesting factors. There was some expert evidence on the exclusion of pension interests and its disproportionate impact on women. KG was obviously considered. EB versus ER/NO was considered. Section 9(1) of the Constitution, the Equality Clause, Section 9(3) of the Constitution, discrimination, and Section 172(1)(a) of the Constitution. The court, in fact, in this instance, did declare Section 77C of the Divorce Act unconstitutional and inconsistent and invalid with the principles of the Constitution. Now, the notable quote from this judgment can be found in paragraph 38 of the judgment, which I will read out to you now. This is best explained if regard is had to the judgment of the Constitutional Court in EB versus ER. Judgment handed down contemporaneously with a judgment in KG and reported under the same reference. In that case, there was a challenge to Section 7(3) because it permitted redistribution only on divorce and not on death. The Constitutional Court found that the differentiation was not rationally connected to a legitimate government purpose and was therefore contrary to Section 9(1) of the Constitution. As explained by this court, the redistribution remedy was introduced to ameliorate the hardship which might be suffered by spouses in marriages out of community of property. The hardship would arise without regard to the way in which the marriage was dissolved, and the court obviously having regard to the broader implications of the Section 7(3) remedy and the manner in which it is applied. This is GD versus Minister of Home Affairs and others, Eastern Cape High Court, declaring Section 77C of the Divorce Act unconstitutional insofar as pension interests are not envisaged in a Section 7(3) redistribution claim. Now, as we know, this matter must first go to the Constitutional Court for confirmation of the declaration of invalidity, and once that judgment becomes available, I will share it in a following edition of the Family Law Roundup. Right, that was Renasan AJ, Eastern Cape High Court, GD versus Minister of Home Affairs and others. Citation, I'll pop back on your screen, ZAECQB HC1. Next up, folks, we are going to the judgment of Windell J in Gross versus DN, which we dealt with a few months back in its unreported form. This was delivered on the 6th of August, 2024. It has now been reported and now forms part of the law reports. The citation in the SA law reports is Gross versus DM 2025 to SA 172 GJ. I have inserted the SAFLI reference for you to still find it on SAFLI on your slide. The full citation is on the course pack for those of you who would like to purchase the course pack. This is an exception based on divorce and dealing with a peregrinus of the court. Plaintiff seeks dissolution of marriage and claims that assets, including a property in Clifton, Cape Town, are held in nominee arrangements by one Mr. Gross on behalf of her husband. Gross raised an exception, arguing that the court lacks jurisdiction over him as a foreign peregrinus. The plaintiff requests the development of the common law and challenges the constitutionality of Section 21 of the Superior Courts Act. Now, in this instance, the court looked at jurisdiction over a foreign peregrinus under Section 21 of the Superior Courts Act. There was consideration of common law developments to address jurisdiction in modern cross-border context, which we know, folks, is becoming a topic of more and more interest as people, and specifically South Africans, become more globalized, and then obviously the constitutional challenge. The exception was dismissed, and the court held at paragraph 60 and 61 as follows. The court states the following. The excipient submits that the relief sought is drastic and devoid of any legal foundation. I disagree. At most, the plaintiff's claim against the excipient and the concomitant relief sought can be described as novel and unprecedented. At the exception stage of the proceedings, this court is not obliged to determine the questions of constitutional invalidity and development of the common law. The determination before this court is whether the plaintiff has pleaded with sufficient particularity to establish a triable issue against the excipient. I'm satisfied that the question pertaining to the development of the common law and the validity of Section 21(2) of the Act has been properly pleaded and is not vague or embarrassing. The constitutional challenge to Section 21(2) postulate factual inquiries which can only be addressed during the course of a trial. The exception, as I mentioned, dismissed. This is the now reported judgment of Wendell J. in Gross versus DM from 6 August last year. Next up, folks, we go to the North Gauteng High Court and the decision by Koch AJ of HCC versus CC, which has now also been reported, and our SA Law Reports citation of this matter is HC versus CC 2025 1 SA 429 GP. This is a divorce based on Section 7.3, and it entailed the redistribution of assets, or the Section 7.3 claim finding its basis in the divorce. Parties were married out and out, the marriage broke down, and the plaintiff sued for divorce. The plaintiff financially cared for the defendant and the minor child, and the defendant has since been unemployed for almost 12 years. Various issues were ventilated in this matter, including Section 7, 2, 3, and 4 of the Divorce Act, Section 7.3 specifically being the redistribution, Section 7.5D being any other factor that the court may take into account, and then EB versus EI being Section 7.3 was also considered. The divorce was granted. A redistribution was also granted in that the property of the plaintiff be transferred to the defendant, PRR awarded to both parties, maintenance of both defendant and minor child granted. And the court states, when talking about EB at paragraph 72, which is our notable quote, EB must be read in context when considering how Section 7.3 should be applied. All legislation must be interpreted and applied through the prism of the Constitution. The Constitution is a transformative document inter alia committed to the achievement of substantive gender equality. The mischief that Section 7.3 aims to address must now be identified in light of constitutional considerations such as substantive gender equality. The mischief that Section 7.3 was originally aimed at was to allow a marriage party to claim a redistribution of assets where a party concluded their marriage during a time when the accrual system was not available in South African law. Section 7.3 in its original form did not allow for a redistribution when the parties concluded their marriage during a time when the accrual system was still available, and the parties still, in the court quotes, chose to exclude the accrual system from their marital dispensation. EB qualifies Brisley versus Drotsky and the Barkhuizen and Napier judgments of the Supreme Court of Appeal in the Concord In this context, contractual freedom does not reign supreme. That the parties concluded an ANC excluding accrual is at best one factor to be considered. The overriding aim of Section 7.3 is to equitably address the plight of stay-at-home spouse after divorce and to prevent gender inequality. If contractual freedom is to be given primacy in Section 7.3 claim, it will nullify the remedial purpose of this section. I do not regard the defendant's failure to provide any evidence as to why the accrual regime was excluded from their marriage as fatal to their Section 7.3 claim. And this, I believe, the HC judgment by Cock AJ being a very nice summary of what was decided in EB and in KG. And I like the way that this court, in this now reported judgment, sets out the mischief sought to be remediated in terms of the judgment, or in terms of Section 7.3 at least. Right, that was divorce. Now we are going on to Hague Convention matters, and I have two judgments that I would like to share with you. One, which is a recent judgment in Central Authority of Republic of South Africa and another versus CM. And the second one is the now reported, and this is no surprise that it has been reported, CAR versus Central Authority SCA judgment from June last year. First off, let's go into Central Authority versus CM. This judgment lands on the 10th of February 2025 from the Court of Adams J in the South Gauteng High Court in Johannesburg. Our Safley citation, ZAGPJHC 99. This court deals with the issue of abduction and a father seeking the return under the convention of a child to a lot in Israel. The respondent raises a section or an article, apologies, 3B defense or 13B defense, and the court is seized upon to determine whether the child should be returned to Israel or whether the Article 13B defense and what I haven't mentioned in our little head note, the Article 12.1 defense, which was also raised by the respondent, should be upheld. Now, the Central Authority was the first applicant. The second applicant was the father of the minor child, applied for the return under the Hague Convention. The respondent, being the mother, being the party who removed the child to South Africa, opposed the return on the basis of, one, the removal was not wrongful, and then secondly, that the return would cause grave or have the risk of grave physical and psychological harm, based on findings by a curator ad litem. Now, as you know, friends and colleagues, under the Hague Convention, if there was acquiescence to the removal of the child from the initial state or the habitual residence state, then the removal is not considered to be unlawful. In this instance, the respondent claimed that the father had consented in writing to the removal. Further, the curator ad litem in this matter had findings and stated that the child has settled into her life and environment in Johannesburg and has no recollection of her life in Israel. The aspects covered, folks: Article 12.1, which outlines the circumstances where a child shall be ordered to be returned. Secondly, Article 13 and 13B being the exceptions to the child's mandatory return under the convention. The court looked at the judgment of NM versus Central Authority and another, and key factors dealt with in this judgment for the return of a child. In this instance, the application was dismissed. The court stating from paragraph 14, 15, and 16 of the judgment as follows. For this reason alone, the application should fail. The simple point is that all of the jurisdictional facts required in order to invoke the obligatory provisions of Article 12 are not present in this matter. And the first hurdle to get across is to prove that the child was wrongfully removed. If there is no proof of a wrongful removal or retention, you do not get out of the starting blocks on a Hague Convention application. Moreover, more than a year had passed since the date of the removal of the minor child, being 30 March 2021. That's how long this matter took to be ventilated in court, to the date on which these proceedings were instituted, 2 August 2023. It is also the case on behalf of the respondent that if returned to Israel, the minor child would be exposed to grave risk or be placed in an intolerable situation. In that regard, the report by the curator ad litem is, in my view, instructive. Paragraph 16 says the minor child has been residing in South Africa since 31 March 2021, and therefore just a period of just under 4 years. The Hague Convention application was issued by the first applicant on 2 August 2023, almost 2.5 years after the respondent and the minor child arrived in South Africa. It is not mandatory for a court to order the return of a child where it is established that the court proceedings are commenced after a period of 1 year from the date of the wrongful removal or retention of the child and where the child is now settled in the new country. Article 12 in the relevant part reads as follows. The judicial or administrative authority, even where the proceedings have been commenced after the expiration of the period of 1 year referred to in the preceding paragraph, shall also order the return of the child unless it is demonstrated that the child is now settled in the new environment. So for several reasons in Central Authority versus CM, the court declined to order the return of the minor child to Israel. Next up, folks, we go to the now reported judgment of CAR versus Central Authority of the Republic of South Africa and another. This is now reported in the SA law reports as CAR versus Central Authority South Africa and another, or CAR at least, versus Central Authority South Africa and another, 2024 6 SA 351 SCA. This is an Article 13B defense on appeal to the Supreme Court of Appeal. It was an application under the Hague Convention for the return of a minor child to Canada. The father appealed against the decision of the Gauteng Division of the High Court Pretoria, which dismissed the application for the return of the child. And the core issue in this instance was whether there was a grave risk of harm if the child were to be returned to Canada. The judgment looks at the Article 13B defense, which deals with the grave risk of harm, and then it looks at the burden of proof in an Article 13B defense. In this instance, the appeal was upheld and the order was made that the minor child be returned to Canada with the imposition of specific protective measures in respect of the return. Our notable quote from this judgment is paragraph 22, and let me just take a sip of my coffee, which states, "It is clear that what constitutes the risk of harm will be determined by the fact of each case and the nature of the projected harm. Although a child's best interests are central to legal decisions involving children in the context of an application for a return order premised on the Hague Convention presupposes that the child's best interest is served by their prompt return to their country of habitual residence. As such, the concept of the best interest of the child must be evaluated in the light of exceptions set out in Article 13b of the Convention. A court that is considering an application for the child's return premised on the Hague Convention must not only consider the allegations of a grave risk for the child in the event of the granting of a return order, but must also consider any undertakings made by the applicant parent in an effort to obviate the eventuation of that harm. As we know, there was quite a lot of discussion, or there is quite a lot of discussion ongoing on this issue of undertakings by the applicant parent and the efficacy of those undertakings. That was our now reported judgment of CAR versus the Central Authority of the Republic of South Africa. This was a judgment on 21 June 2024, and our quorum at the Supreme Court of Appeal, which I didn't mention to you, was Molemela P, Mukumi ADP, and then Goosen and Molefe JJA and Mbele AJA concurring. Apologies, it's that was Molemela P and Mukumi ADP. Right, incidentally, I'm going to start mentioning my bundle and my summaries pages, which I have very negligently forgotten to mention to you folks up to this point. So I do apologize sincerely for that. As we go into our next section, being our maintenance judgment, I will give you the relevant bundle and summary page numbers. And I apologize for that omission, folks. Next up, we go to the topic of maintenance, and specifically the obligation of a deceased estate for the maintenance of minor children, and minor children specifically who are the sole beneficiaries of the deceased estate. This is LL versus AJM and others, ZAGP PHC 523, now reported as LL versus AM 2025-1 SA 455 GP, and this is from the Court of Neukircher J in the North Gauteng High Court. Bundle page, before I forget, folks, 130, and summary page 7 for those of you following along. Let's start with the facts of this matter. It was a maintenance claim brought by the biological mother on behalf of her 2 minor children against the deceased estate of the father. The claim was initially rejected by the executors on the grounds that the mother had not demonstrated her inability to maintain the children and had not made a disclosure of her means in order to calculate the respective shares of maintenance. Court was asked to decide whether the estate has an obligation to contribute to the maintenance of the children without requiring the surviving parent to first prove an inability to maintain, and this is specifically under circumstances where the children are the sole beneficiaries and would in due course have the benefit under the will. And essentially what the court looked at here is the obligation to maintain minor children, which extends to the deceased estate of a parent. It was decided on exception. The exception was dismissed with costs, and our notable quote comes from paragraph 20 of the judgment, where the court determines the following. If the executor steps into the shoes of the deceased and he assumes the maintenance obligations of the deceased, it stands to logic that principles generally applicable to maintenance claims for minor children must be applied, i.e. that the duty of support falls to both parents according to their means. What their means is informed by the evidence placed before the court at the time of the inquiry and on the executor in accordance with his duties to utilize the assets, finances, and income of the deceased estate to maintain the children in accordance with the general principles applicable. That is LL versus AJM and others, and that is in the Court of Neukircher J, now reported LL versus AM 2025-1 SA 455 GP. Next up, we go into two very interesting judgments on the topic of mediation, folks. Now, I'm going to start with our Johannesburg judgment, and then I'm going to go to our Western Cape judgment, both equally interesting. So first off, I'm going to go into the matter of QNM versus MNM. I see that StreamYard has once again disjointed my poor slide, so the text is not available on your screen. I will read out the full citation, so please do take note. QNM versus MMM bracket 2022/013249 close bracket, open bracket 2024 close bracket, ZAGPJ HC 1317, and the date 12 December 2024. This judgment emanates from the Court of Friedman AJ, and you can find it in your bundle on page 201 and in your summary on page 9. This is a Rule 43 application. Salome asking MM or NM, and I think it is very important. Let me spell it out phonetically for you guys. So it's Q, N for Nelly, M for Mary, versus M, M, M. So 3 times M for Mary. So let me pop it in here, Q and M versus MMM. There we go. It should go out on all our platforms, incidentally. Right. Now, being a Johannesburg matter, this matter deals with the practice directive, and specifically the consolidated practice directive 1 of 2024, which has our directive for the family courts. It is a Rule 43 matter, and the judge dealt with mediation compliance in terms of the revised consolidated practice directive 1 of 2024. Now, paragraph 29.13, folks, gives the presiding judge the discretion to stay the proceedings to afford the parties an opportunity to reflect on the issue and to go to mediation and not allow re-enrollment until the parties have adduced cogent evidence that mediation has been considered, and if they don't mediate, why, in their view, they contend it would be fruitless to attempt mediation. Now, that is the backdrop of paragraph 29.13 of the revised consolidated practice directive. If any of you do not have that practice directive, I'm sure if you pop a message on the ThinkLegal family law group, you will get someone who will share it whilst I'm busy presenting. If they don't, then I will just share it again after the session today. For those of you who are not yet on the family law WhatsApp group, where are you and why is your head in the sand? Go to thinklegal.co.za, join the group. It's free. It's just under 700 family professionals all across South Africa, speaking very robustly and frequently on all things family law. So back to QNM, folks. This is the Rule 43 mediation compliance before Friedman AJ. So the applicant brought a Rule 43 seeking provisions for expenses relating to care and school fees. And what had happened is that initially respondent had only filed a notice of intention to oppose but not an answering affidavit. Respondent was given leave to file a reply, which was subsequently within the time frames which were given. The court found that the parties had failed to meaningfully explore mediation or to provide cogent financial disclosures. The judge issued a directive requiring mediation efforts before proceeding with the Rule 43 relief. Here comes the problem, is both parties ignored the directive and they engaged in a blame-shifting tug of war via correspondence rather than going into mediation. What happened eventually on this date when the matter fell before Friedman AJ, or landed before Friedman AJ, the Rule 43 was stayed pending compliance, and an order was made that the Rule 43 may not be re-enrolled until evidence adduced that attempts on engagement on possibility of mediation had been made. In this instance, the notable quotes are at paragraph, sorry, I'm just quickly replying to someone looking for me. Paragraph 9 and paragraph 16 of the judgment. Now, the notable quotes, sorry for that, folks, are very, very interesting. Paragraph 9, the court sets out the contents of the directive, which I put in there for you for background, for those who might not have the directive. Paragraph 16 is the court's reasoning and also a bit of a cautionary tale to all of us regarding mediation. Now, paragraph 9 reads, because of the previous attempts at settlement of this matter and because of what I've said above, on 26 November 2024, I issued a directive in terms of paragraph 29.13 of the directive. The directive empowers a judge sitting in the family court, if not satisfied that appropriate efforts have been made to mediate a dispute which appears to be susceptible to mediation, to exercise the discretion to stay the proceedings to afford the parties an opportunity to reflect on this issue and not to permit re-enrollment until the parties have adduced cogent evidence of having properly engaged on the aspects of mediation and to explain why, in their view, it would be fruitless to attempt mediation. So Friedman AJ very alive to this aspect of mediation in the practice directive. Paragraph 16, the court has some very strong words. The reason why this matter cries out for mediation is that the applicant is being ill-served by her attorney in following a classically adversarial approach to litigation, which should be, in my view, a bit of a cautionary tale to all family law attorneys. Her papers are not clearly drawn, and what is said in the main affidavit is often contradicted by the documentary evidence offered as proof. The applicant is the other debtor in the joint estate, but has given no evidence whatsoever of any steps taken by her to protect her interests in the joint estate, such as making her own inquiries, etc. In this instance, the court stayed the proceedings pending evidence being adduced that attempts on engagement on mediation have been made. That is QNM versus MMM, and that is from the South Gauteng High Court, Johannesburg. So I've decided to do this one first, even though it appears second on our summaries, because I think it flows nicely into our next judgment, which is FCP versus STC, right at the bottom of your slide. And this is an appeal that came from the maintenance court, Wynberg, to the Western Cape High Court and fell before Gordon Turner AJ. Our reference SAFLI citation is ZAWC HC 68. My apologies. It is on the blue part there, so you cannot see it on your screen. You can find this very interesting judgment at page 146 and the summary you can find on page 8. It is a 55-page judgment. It is not exactly what you will call light bedtime reading. It is a very interesting judgment dealing with various issues, including termination of parental responsibilities and rights, as well as this issue of if you terminate PRR, what happens in respect of maintenance. I'm not going to go into that too much, although I do need to mention that this is a very interesting aspect covered in the judgment, and I think the court per Gordon Turner AJ has given us some very interesting food for thought and precedents, both as obiter dicta and ratios in this matter. However, I am going to focus on the mediation aspects because the court did something very interesting. I see Angelique asking on LinkedIn for a copy of the practice directive. I'll try to get it through to you on LinkedIn. Otherwise, please go to thinklegal.co.za, apply for the WhatsApp groups. We'll add you, and then I'll make sure that it gets distributed there as well. The facts of the matter are convoluted, so I've summarized them very, very obliquely. We can't, in a little table like this, summarize the 55-page judgment, but we did our best just for background. The appellant is the biological father of a 13-year-old child. He had denied paternity and avoided engaging in maintenance until November 2022, when paternity was then confirmed through legal processes. Maintenance proceedings were initiated against him in 2023, January, and then shortly thereafter, he applied to the Children's Court to terminate his PRR. In fact, he applied just 8 days after being served with the maintenance claim, which gives pause to anyone considering this matter critically. He admitted in his application that his primary motivation was financial. He claimed that the child's mother only contacted him for monetary support following the divorce, or her divorce. He argued that the circumstances were not conducive to a relationship with the child and framed his application as an attempt to avoid financial obligations. Children's Court granted, for whatever reason, the termination of PRR without appointing legal representation for the child or obtaining reports from social workers or family advocates. Now, this matter then made its way to the court of Gordon Turner AJ, with this partial kind of history, with a further history from the Wynberg court as well. Obviously, in this judgment, the court looks at Section 21 of the Children's Act, which is a section dealing with unmarried fathers. And then the court also looked at GM versus KI, which is that it's not the intention of the legislature to terminate rights, but leave in place responsibilities. Now, what was very interesting in this matter is the appeal was dismissed with costs. However, what happened here is that the parties were ordered to go to mediation. And I find that very interesting. And I think this is one of the first judgments of which I'm aware where a court orders mediation, and it takes it a step further from previous instances where courts have stayed proceedings or have refused relief where there hasn't been mediation. But to my knowledge, this is a interesting judgment, or to my knowledge, this is one of the first judgments where parties were overtly, in a family law matter, ordered to go to mediation. So what had happened here is the parties were ordered to jointly approach the family advocate for mediation, and that they should use all endeavors or all reasonable endeavors to reach agreement. However, there was a time frame imposed on this where if mediation does not succeed, the parties are required to notify the maintenance officer and request the earliest available date for resumption of maintenance proceedings, the court taking the view that the child should be maintained despite any ostensible termination of PRR. Paragraph 86 of the judgment, folks, is our notable quote here, where the court looks at the judgment of Moscovich AJ, where they invoked a mandatory mediation possible under Section 21 of the Children's Act. That does not apply to the present matter. However, I consider that the guiding principle of Section 6.4 of the Act, and now this is the Children's Act, which requires, which essentially forms a two-legged kind of approach, where number one, you should approach the children's matter in a conciliatory and a problem-solving manner. And I paraphrase, that's not exactly how it's stated in the Act, but those are the key principles of the first part. The second part, any delay in making a decision should be avoided. And those are the two parts of Section 6.4. The court now says in FCP versus STC per Gordon Turner AJ that the guiding principle in Section 6.4 of the Act, which resonates with the underlying dicta above, affords this court the power and indeed the duty to direct the parties to attend further mediation with the family advocate, in accordance with the order and structured timetable set out below. The purpose is to obviate any need for the parties to return to contested court proceedings in the maintenance court or in this court. The parties remain free to secure independent advice from their respective legal representatives on the terms of any mediated agreement. So in this case, Gordon Turner AJ ordering the parties to mediate the matter. Now, there are various aspects to take into consideration on this judgment. I enjoyed having discourse in the session I did for social justice a week or two back on recent mediation judgments, and we discussed and debated this judgment. But I'd also love to hear all of our attendees today's input on what their views are on this judgment. But essentially, mandatory mediation really is not as new a concept in South Africa as we may think. Notable examples, I can thank you to Pratima Osman for alerting me to this in Land Claims Court. There is a process which I believe is very much akin to mediation, which is mandatory in the CCMA in terms of the Labour Relations Act. We have CON-ARB process, conciliation, arbitration, which is very much a mandatory type of mediation process. And now, in this instance, in FCP versus STC, the High Court in the Western Cape invoking mandatory mediation for the parties. Is this constitutional? Is it consistent with the rights of individuals under Section 34 of the Constitution, which essentially guarantees access to courts and a fair and public hearing in an impartial and independent tribunal? Is this inconsistent with that constitutional right if we were to invoke mandatory mediation? And further, if it is inconsistent with Section 34, does it pass muster in terms of the limitations clause in the Constitution? So I'd love to hear from you. Please share your views in the comments as well as on the WhatsApp groups. I would love to hear what your views are on this very interesting issue of mandatory mediation or court-ordered mediation, citing Section 6.4 of the Children's Act as an empowering principle. Right, folks, that finishes part 1 of the Family Law Roundup. We still have part 2 and part 3 to go. In part 2, we're going to go through Procedure, we're going to go through marriages, and then in part 3, we're going to go through children's matters and Rule 43 matters. At this juncture, I thank everyone who has been supporting me by purchasing our optional course pack. It is a wonderful way to help what we round up to make it feasible for us and to support the ThinkLegal initiative. For those of you who are interested to purchase the course pack, please go to thinklegal.coza. In the course pack, you get the summaries, which I work from, which look like so. You get a table setting out the citation, the judge, the court, the principles, the background, the outcome, and a notable quote to use in your practice to fast track you into the judgment. You also get a bundle of judgment paginated. In today's instance, it is just under 560 pages of judgments, which we compiled into a bundle for you from SAFE, and you also get 2 SAAM CPD points if you purchase the optional course pack. For those of you who are not inclined to purchase the optional course pack, you are still more than welcome to attend today's session with us, which is absolutely free of charge in accordance with our commitment to making legal knowledge freely available to everyone. On that note, folks, let's go on to part 2. Salome says, in terms of mediation, mandatory mediation, I think there's a value in compelling, not forcing parties to make a sincere effort. I think there is a lot of value to that statement, Salome. I had an interesting perspective from a mediator who kind of said, you know, if the mediator is worth their salt, they will have the necessary skill set to bring a recalcitrant party to a table. Pratima says, discussions yesterday on the virtual meeting on Project 168. Oh, Pratima, I'm livid that I missed that one. I was in consultation with the SALRC, indicate a strong leaning toward mandatory mediation. While it deals with mediation civil matters, it's likely that this will be the approach for family law and community mediations. And then in addition to that, Pratima, we also have the Family Dispute Resolution Bill, which seems to be coming through, or seems to be inching its way forward to a finish line at some point in the future. Righto, folks, let's go into procedure. And first off, we are going to start with KG versus DG and others, ZA-GPPHC 130, and this is from the Court of Nyati. J, for those of you who would like to follow along, we are in bundle page 212 and summary page 10. KG versus DG and others, Pretoria High Court. This is an anti-dissipatory interdict in a divorce matter subject to the accrual system where there was a settlement agreement. Now, we know that we have in an anti-dissipation interdict, we have those requirements in Knox to RC from the Supreme Court of Appeal, and the SCA at a later stage also making it clear that Knox to RC has not gone the way of the dinosaur, despite a line of High Court judgments considering the contrary, and Knox to RC remaining very much alive in the South African context. In this instance, the applicant sought an anti-dissipation interdict to restrict and interdict the first respondent from alienating, transferring, or encumbering the immovable property belonging to the respondent pending finalization of their divorce, in that it was to be transferred to them pursuant to a settlement agreement. Furthermore, they were residing there with the minor children. The first respondent opposed the application on the basis that he is impoverished and that he needs to sell the property to comply with a Rule 43 order. Oh, shame. The applicant and the first respondent are embroiled, in this instance, in a very acrimonious divorce where the applications had been, where various applications had been brought. There was some controversy on the settlement agreement and whether the settlement agreement was exited from, and if so, who exited, etc. But what the court essentially looked at was the principles of Webster versus Mitchell and the Nelson Mandela Metropolitan Municipality versus Gravenose CC. The court interdicted and restrained the first respondent from alienating, transferring, or encumbering the property pending finalization of divorce, and gave an attorney-client scale costs order against the first respondent. Paragraph 33, short and sweet, is our notable quote. It is tried that the court exercising its discretion must balance or weigh the prejudice which the applicant will suffer if the interim interdict is not granted against the prejudice that the first respondent will suffer if it is granted. Short and sweet and classic, that is our notable quote from KG versus DG under the pen of Nyati J. Next up, folks, we go all the way to the Limpopo High Court in Polokwane, and this is a urgent contempt of court, contact and care, relocation, enrollment at school, and essentially bona fide actions in disobedience of a court order. We put it under the heading of procedure this time round, but as you can see, it has some very big elements of contempt of court. Now, your SAFI citation, ZALMP PHC 21, and we are before Kanyaho J, and your bundle page 221, summary page 11 for those of you following along. It was a dispute between divorcing parents over primary residence of their child. Mom wanted to relocate to Adamaru while the father opposed the move and secured an interim court order allowing rotational residence between them. When the father failed to comply with the agreed arrangement, the mom brought an urgent contempt application against him. And essentially what it really boiled down to was the enrollment of the child at a school, which precipitated a situation where the child would have to stay in one place despite the mother's relocation. The father opposed the application, filed a counter application seeking to vary the order so the child would remain in his care pending finalization of a forensic investigation and evaluation, arguing that the child's schooling in Messina, which is where they had previously agreed to enroll the child in school, was paramount. And that is where we get to this idea of bona fide actions which are in disobedience of a court order, and the court order, as I understand it, being 1 week kind of rotation contact, which is now undermined due to the child being enrolled in the school. Court looked at Fakey versus CCII, which is our locus classicus for contempt matters, Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, etc., versus Zuma, which also sets out the elements of contempt of court, and then Stock versus Stock. The application for contempt of court was dismissed. The respondent's conditional counter application granted, and each party was ordered to pay their own costs. And paragraph 18, folks, our notable quote reads as follows. By enrolling the minor child in a school in Messina, the respondent was acting in good faith. Now, understand again, folks, that this is contrary to the terms of a court order. But it was in good faith and his actions were not unreasonable. In my view, says the court, even though the respondent has acted unilaterally, had conceded that he refused to obey the court order of 10 December 24 and did not attempt to vary that order, his actions were not willful and mala fide. He mistakenly thought that he was doing the right thing, which was in the best interest of the minor child. It follows that he cannot be found to be in contempt of the order of the 10th December 2024. Essentially, the court putting a lot of weight on the fact that it's in the best interest of the child to have adequate access to schooling and that it was not mala fide for the respondent to have enrolled the child in the school in Musina. It is an SCA judgment from the 13th of June 2024, which was now reported in the final law report of 2024, that is KSL versus ASL 2024 6 SA 410 SCA, and that is obviously the SCA. The quorum, Zondi, Mukhohloa, and Mabindla Bukwana in this matter. The bundle page for KSL, page 232, and summary, page 12. And this is an anti-dissipation interdict, and it's a discussion on Knox d'Arcy. I mentioned to you earlier that the SCA once again exonerated itself regarding Knox d'Arcy relief, and that is the requirement for anti-dissipatory relief. It is not a normal interdict. It has the additional requirement that there is intent to defraud when it comes to anti-dissipation interdicts in terms of Knox d'Arcy versus Jamieson, etc. The judge having some very strong words against the High Court in paragraph 29 of the judgment, which stated, as stated above, as JLT and the cases that follow it do not reflect the correct legal position. Should imagine being one of the parties in one of those cases and getting this judgment. Knox d'Arcy, a decision of this court settled the matter on the requirement of intent in anti-dissipation applications. The High Courts were bound to follow the decision of this court, which is precedent. Following precedent is not simply a matter of respect for higher authority, it is a manifestation of the rule of law itself, which in turn is a founding value of our Constitution. So KSL, making it absolutely and patently clear that Knox d'Arcy is alive and well in our law, and that this is the requirement for anti-dissipatory relief. And we are doing quite well with time. We will be out of here before 11 o'clock, folks. I'm going to look at some comments. Barbara says mandatory mediation works well in other countries. Some parties have a preconceived idea of what mediation is, often negative. But when they get there, they realize that it is worthwhile, and they come around and the process works. Very, very good point, Barbara. And that also underscores the importance of mediators being well-trained specialists in bringing parties to the table in a mediation process. I think actually we might do a webinar on this at some point, but let's see how my time looks and whether I'll get into a lot of trouble with my colleagues and my wife for putting on too many webinars. So let's move on. Thank you for that feedback, Barbara. Very, very good sound feedback. Next up, we have another now reported judgment. It is Investec Bank versus Singh and another. It is before Cowan J, and it is now reported in the law reports in the first edition of the 2025 law reports as Investec Bank Limited versus NS and another 2025-1 SA 210 GP. And folks, this just once again really underscores the importance of focusing on our unreported judgments as well. Do make sure that you follow your unreported judgments. If you do not have a nice place to get hold of them, have a look at Spartan Case Law. Get in touch with Louis and his team. They are very, very affordable, and you get daily updates. Why do I say this? This judgment was penned in July 2024. It reached the law reports only in January 2025. It's not to say that the law reports are not great, but we do need to be on the cutting edge of what happens. The only way to do so is to also have regard to our unreported judgments. Also, obviously, another way to stay updated is to follow the family law roundup. Right. This is a North Gauteng High Court decision, and for those of you following along, it's on bundle page 247 and summary page 12. It's a sequestration with a joint estate of a marriage in community of property, and it looks at section 15.6 of the Matrimonial Property Act. Now, folks, you'll know section 15 of the Matrimonial Property Act talks about the powers of spouses to transact on behalf of the joint estate and the requirement of consent in certain instances. So the bank sought to sequestrate the joint estate of Singh and Killick due to alleged debts exceeding 189 million rand. Sure. Primarily arising from guarantees Singh provided for obligations of two companies, which are named in the judgment. The guarantees included working capital facilities, term loans, and finance agreements. The business was central to Singh's business operations in South Africa, while its subsidiary, Ghana Infrastructure, operated in Ghana. The company was placed under provisional liquidation in late 2022. Section 15.6 of the Matrimonial Property Act was considered by the court, and specifically the fact that guarantees bound the joint estate, while guarantees binding the joint estate being subject to spousal consent for certain transactions. The court had a look at these provisions and essentially Thank you, StreamYard, for kicking me out of my presentation. Apologies for that, folks. Can I please just get a thumbs up from someone that you guys can see me and that I'm not speaking into the void due to technical issues? Apologies for that once again, friends and colleagues. Okay, it seems like I am up and running, and I really, truly, honestly hope that I am. Okay, fantastic. Barbara says that you guys can see me. I'm just going to put my correct phone on again. You guys should hear me quite nicely now. And I sincerely apologize for that, folks. Let me just get back to my right slide. All right. And here we are. Part 2. Whew. Panic over. Good. The joint estate was placed under provisional sequestration, and a rule NISI issued on all persons with a legitimate interest to advance reason why final sequestration should not be granted. Our notable quote in this instance, folks, is paragraph 65, referring to the SCA, where the court says, the SCA has held, when interpreting section 15.2H and section 15.6 of the MPA, that the question is not whether a spouse normally stands surety in the course of their business, trade, or profession, but whether the single juristic act in question was performed in the ordinary course of the spouse's business. The authorities are moreover clear that section 15.6 applies where a spouse conducts his or her business through a company or closed corporation, as Singh does through at least BIG and GIC. Indeed, but for the peculiar circumstances of this case, the parties were ad idem, in my view correctly, that the BIG guarantees were in their nature guarantees supplied in the ordinary course of Singh's business, as contemplated by section 15.6. Now you'll note section 15.6, folks, is a caveat to our section 15.2 and section 15.3 limitations on spouses in community of property. And the limitation, as I'm sure you would have guessed, is if those guarantees are issued in the ordinary course of the spouse's business. I am almost scared to touch my mouse for fear of getting kicked out again, but let's see what we can do. And thank you again, everybody, for your patience. Next up, we go to marriages, and we are going to be dealing with several customary marriages in this month's Family Law Roundup. The first one is Manwadu versus Manwadu and others. It is a Supreme Court of Appeal judgment on the 10th of February with Weiner J.A., with Molefi J.A., Koppen J.A., and Dippenard A.J.J.A. concurring, and Makhoka J.A. dissenting. It is an appeal dealing with the proof of a customary marriage. You can find it, for those following along, in your bundle at page 290 and summary page 13. It deals with the validity of a customary marriage and a subsequent civil marriage. And the facts of the matter were as follows. In the court of quo, the first respondent brought an application to declare their customary marriage with the deceased as valid, and the civil marriage between the deceased and the appellant as null and void. The appellant brought a counter-application to declare their customary marriage with the deceased valid, and that the customary marriage between the first respondent and the deceased as dissolved. The respondent in the application attached an uncertified copy of her ID reflecting the deceased's surname as prima facie proof of the existence of the customary marriage. They sought to rely on this document. The appellant brought an appeal to the SCA challenging whether the respondent proved that there was a customary marriage between first respondent and the deceased, as it was common cause that the copy of the first respondent's ID was not certified. And it's funny that a matter in one of our highest courts turns on an aspect as simple as whether an ID copy was certified or not. The court looked at Section 3.1 of the Customary Marriages Act, Section 4 of the Customary Marriages Act, or the Recognition Act at least, Section 20 of the Civil Proceedings Evidence Act, and W versus W, which is proof required in respect of validity of a marriage certificate. The appeal is upheld, and essentially the turning point here goes to paragraph 48 of the judgment, which reads as follows. All of these omissions render the reliance on one uncertified, disputed document, which is not a copy of the marriage certificate, misplaced. The onus was on the respondent to prove the existence of the customary marriage. In seeking to rely on the ID document, no explanation was tendered for not preferring the original or at least attaching certified copies of it. But even that could not relieve the respondent of the burden of proving the marriage, the existence of which was challenged by the appellant and several witnesses who were relatives of the deceased. Simply stating in one paragraph that neither Home Affairs nor the magistrate's office could assist her is a blatant disregard for the rules of evidence. Corollary evidence could easily have been produced. The respondent, again, despite the challenge in the appellant's answering affidavit, failed to refer to even one person who confirmed her allegations about the traditional ceremony and other customs having been observed, and a customary marriage having been concluded. Neither did she show that the traditional rituals of celebrations occurred in terms of vendor law. In such a case, and considering the blatant untruths contained in the respondent's affidavit, it would not be appropriate or safe to accept the ID document as proof of the customary marriage. Turning point on this matter, whether the uncertified document was sufficient. Obviously, various other factors at play. The respondent did not bring any other witnesses to attest to the requirements in terms of Section 3.1 of the Recognition Act, and merely relied on one document which was in dispute. That was Manwadu versus Manwadu and others. Quite interested to know why this is full surnames and why it is not also abbreviated for POPI purposes. I would love to hear if anyone knows why that might be the case. And we see it quite a lot specifically with customary marriages. Some are abbreviated, some aren't. If anyone knows what the policy is in terms of SAFLI for that, I would love to know. Next up, we go to the Northern Cape High Court, Kimberley, and this is a court we don't see pop up all that often in our family law judgments. And this is from the Court of Williams J on the 7th of February 2025. This is NVM versus DSR, almost bringing us to the penultimate judgment of our part 2 of the family law roundup. It is a trial matter. It deals with the customary marriage and the validity, as in most of these matters. You can find it on page 336 of your bundle, folks, or page 14 of your summaries. Plaintiff in the divorce alleged that she and defendant entered into a customary marriage. The defendant defended the action on the basis that no customary marriage was entered as the lobola negotiations were postponed. Parties agreed before the start of the divorce trial to separately determine the validity of the customary marriage. And we see that quite a lot. We see these separations of those issues where the validity is determined first. The court looked at Section 3.1. Obviously, the court looked at Marupane versus Southern, changing nature of customary law, Mungela versus Nkabi, which is the ritual of bridal transfer is not a critical requirement. And obviously, the court considered witness testimony from both parties on lobola negotiations, and it looked at the lobola letter. The customary marriage was declared valid, and the ratio of the court quite apparent from paragraph 61. What counsel for the defendant has not borne in mind is the changing nature of customary law. Moreover, in Mbungela and another, the SCA, dealing specifically with the ritual of bridal transfer, debunked the view that if one particular ritual has not been observed, there could be no valid customary marriage. We're seeing this more and more, folks. There's a lot of, dare I say, contradictory and disparate judgments regarding customary law. Perhaps not contradictory, that might be a strong word, but we are seeing a lot of judgments coming in thick and fast with different views and rationales behind the outcomes of these judgments. Next up, Mabena versus Ramonaka and others. Back to the Johannesburg High Court in the Court of Minnar, AJ, that is South Gauteng High Court, Johannesburg, and that can be found at page 357 of your bundle and page 15 of your summaries, folks. Once again, validity of a customary marriage. The applicant sought a declarator declaring the customary marriage between them and the deceased valid, that the applicant be the widower of the deceased, that the respondents recognize the applicant as the widower and the heir to the estate of the deceased. First and second respondents denied the existence of the marriage on the basis that although lobola was agreed upon, the remaining cultural rituals were not adhered to. The court looked at Section 4.1 being the registration of a customary marriage. The court looked at Section 3.1 being the recognition of a customary marriage. And once again, reliance was placed on Mbungela versus Mkabi. The requirements are not a sine qua non, or the cultural requirements. If one was omitted, it is not fatal to the conclusion of a customary marriage in terms of Section 3.1 of the Recognition Act. Unsurprisingly, the customary marriage was declared valid, and the third respondent was ordered to register the customary marriage. The ratio coming across in paragraph 12 of the judgment: there is an obligation on courts to be cognizant of the fact that customary law regulates the lives of people, and that the need for flexibility and the imperative to facilitate its development
must therefore be balanced against the value of legal certainty, respect for vested rights, and the protection of constitutional rights. The courts must strive to recognize and give effect to the principle of living, actually observed customary law, as this constitutes a development in accordance with the spirit, purpose, and objects of the Constitution within the community, to the extent consistent with adequately upholding the protection of rights. This was Mabena versus Ramonoka in the South Gauteng High Court, yet another judgment where the customary marriage was upheld. And I dare say, from my readings of these every month, it does seem that the courts are more inclined to recognize customary marriages than to not recognize customary marriages. Next up, we do not have a customary marriage. We have a universal partnership, the Latin, the Societas Universorum Bonorum. Yes, the Societas Universorum Bonorum, a trial based on universal partnership. This is before Bressler AJ on the 19th of February 2025 in the Limpopo High Court, and you can find it on paragraph 366 of your bundle and summary page 16. The plaintiff pleaded in their claim that together with the defendant, they entered into a partnership agreement for gain between themselves and their benefit, that the partnership terminated in April 2019, and the appointment of a liquidator to liquidate their assets and divide the proceeds between them. During their partnership, it was alleged the parties shared their assets and accumulated more movables. Defendant defended the claim, denying that there was a partnership or asserting that there was no partnership. Apologies, there's a typo on my notes, and there were no contributions made to the partnership. The court looked at Hubert versus Terry & Co., Butters versus Mkora, which is essentially our locus classicus on universal partnership from the Supreme Court of Appeal, and Mulman versus Mulman, the principles of tacit agreement of partnership. The plaintiff did not succeed with the claim, and the court's reasoning can be found in paragraphs 43 and 33 of the judgment, which are our notable quotes. I'll start with paragraph 43 and then 33. At paragraph 43, the court states it must be borne in mind that a societas universorum bonorum does not equate to a marriage in community of property. The normal principles pertaining to contributions of spouses in a marriage in community of property will therefore not apply to determining if a societas universorum bonorum came into existence. The mere fact that the parties cohabitate does not entitle them to a proportionate share of the other party's estate. And then paragraph 33, as far as the ambit of the two types of partnership referred to herein before is concerned, the universal partnership proper in principle comprises all the present and future property of the partners. Thus, all the assets which the partners possess at the inception of the partnership, as well as all the assets they obtain during the duration of the partnership from whatever source. The general partnership comprises only the profits derived from all the commercial activities of the partners during the duration of the partnership. RDM versus MDK, constituting a very nice overview of the law as it relates to universal partnership. Folks, that concludes part 2 of today's presentation. Let me get my slides back up. A reminder for those of you who want to get involved, I've seen quite a few applications for the WhatsApp group come through in the last few minutes. I'm going to ask our team to process those today, so you should be up on the WhatsApp groups a bit later today. Those who have applied and who are active family professionals will gain access to our WhatsApp groups. Remind you that you can register for events on our thinklegal.coza website. Upcoming 2 CPD events is Drafting for Divorce in April and Divorce 101 in June, accredited for 5 and 6 SAAM CPD points respectively. For those of you who want to pick up the course pack, you're welcome to go to thinklegal.co.za and purchase it from our online store. For those of you who are a little bit more old school, please pop me an email. My email address on the screen just under my face to the left of my logo on your screen. Please pop me an email. I'll send you our banking details, and I will then provide you with the resources. Resources this month are quite a hefty number of pages, big files. I am going to provide them to you via WeTransfer, as they are too big to email. So when you engage with me, just make sure you give me an email address where I can send it to. Right, going into part 3. We are going into Rule 43, and we are going into children's matters. We've got another 8 judgments to go. Can you guys believe all of the judgments that have popped in to this month's family law roundup? A full 26 judgments that we had to go to. So today, for those of you who are working for your 2 SAAM CPD points, you are working very, very hard, because we are going to go the full hog, I believe, to very, very close to 11 o'clock. Our next judgment, KKA versus KNT. This is from the Johannesburg High Court under the pen of Besaid Note AJ on the 16th of January, even though we only got hold of it on SAFLI in February. Hence, it is part of this roundup. You can find it on page 379 of your bundle and page 17 of your summaries. It is a Rule 43.6 application. The applicant brought a Rule 43.6 on the basis that, or in terms of an order previously granted in respect of contact, as well as an investigation into the best interests of the child by an expert, on the basis that supervised contact is restricting, frustrating, and artificial to the minor child and deprives them of their right to enjoy contact naturally. The respondent opposed the application. As in all matters regarding children, the court looked at Section 7, Section 9 of the Children's Act, our best interest principles, and Section 28.2 of the Constitution, and then Rule 43.6, the grounds for the variation of a Rule 43 order in terms of Rule 43.6. In this instance, the Rule 43 order was varied, and an expert was appointed to conduct an investigation into the best interests and costs of the application to be costs in the divorce action. Court's reasoning is apparent from paragraphs 92 to 93 of the judgment, which I'll read out to you. Having carefully considered the evidence, I find that there exists no factual basis on which a court can continue to impose severely limited contact between the applicant and the minor child. However, the court is cognizant of the fact that the minor child has not enjoyed any sleepover contact or spent any longer than 2 hours every week. Sure, that's bad. With 2 more hours every alternating week for the past 3 years. Bearing this in mind, it would be in the best interest of the minor child that any unsupervised contact that may be reintroduced should be phased in over a reasonable period of time to ensure that the minor child adjusts without any difficulties. The order that I intend to make will provide for a transition period. In addition to the phased-in contact, it would serve the minor child's interest to commence therapy with a reputable child psychologist, not only to assist her with a contact adjustment, but to provide her with useful tools to cope with the divorce of her parents and the effect that has on how she perceives her world. Hence, the order will provide for the appointment of a therapist for the minor child. And that is our notable quote from KKA versus KNT. And that has highlighted something that's been on my mind for a couple of weeks now. And that is the different elements when it comes to law relating to families. And we, as lawyers, are very good at advising on the procedural law elements, the substantive law elements. But I do think we also need to be mindful of the practical effects as a third leg of advising our clients. What is the reality of the law, and what are the implications on the functioning of the family unit? And this judgment, I think, really nicely boils that to the top to say, but there does need to be therapy. Realistically, that is something that needs to be taken into account. So it is not just procedural or substantive law, it also deals very practically with the nitty-gritties. And I think we as lawyers, mediators, etc., I can't really pick on the mental health guys, because that is essentially what they do when they intervene, is look at the implications. But we do need to be mindful of these in our matters. Next up, we go north of the Yukskay after my preaching and proselytizing over this platform. LPWR versus PCSR, and that's on the 6th of February 2025. ZAGPPHC in the Court of Vanderskyf J. You can find it in your bundle on page 415 and page 18 of your summary. It is an urgent Rule 43 dealing with contact and care of a minor child in investigation by the family advocate. The applicant brought an urgent Rule 43 for care and contact, as well as ancillary relief in terms of an investigation. The respondent opposed the application, raising 2 points in limine: that the application is premature, as divorce summons has not yet been issued, and that there is no urgency. I don't believe, if my memory serves from reading this judgment, that the applicant actually framed their relief as Rule 43, but the court kind of viewed it as Rule 43. The best interest principle is looked at, urgency was looked at, and the correspondence between the parties' attorneys was really considered in quite some length by the court. The court said something very interesting. The court said essentially, I paraphrase, the matter is not urgent. It's not going to be enrolled as an urgent application to that effect. However, paragraph 12 and 13 of the judgment, the judge turned and said, having said that, the parties are before me now. I am of the view that it is in the child's best interests to regulate his parents' rights regarding his contact and care, since it might motivate the parents to take a breather and approach the issues more objectively. In the result, an order is granted that deals with the minor's primary residency, care, and contact pending an investigation by the Office of the Family Advocate. The issue of maintenance is not addressed in this order, and in the event that the parties cannot amicably settle the issue of maintenance, the existence of this order shall not be an obstacle to the respondent to approach the court for an interim maintenance order. Essentially, the court granted a Rule 43 style order according to what the court deemed to be the best interest of the child, and not to the relief sought by the applicant. And the applicant was to pay the costs of the application. A very, very interesting judgment when looking at the powers of the High Court as upper guardian and the best interests of the children, or best interest of the child, standard apologies. You can hear my voice and my brain getting very tired indeed, as we are in the final stretch of the family law roundup for this month. So as the court said, take a breather to the parties. So I will also quickly take a breather and just do a deep breath, have some coffee, which has by this time obviously grown quite cold, but at least still very caffeine saturated. So I'm ready for our last 6 judgments for this month's roundup. Next up, we stay in the court of Vanderskyf J in the matter of HA versus NA, ZAGPPHC 121 in the North Gauteng High Court. And this deals with a Muslim marriage and the issue of issuing a talaq and whether that dissolves the marriage. Bundle page 421 and summary page 18. I found this judgment quite interesting. I found the principle which was established quite clear and crisp. However, At least now we have case law that deals with this. The applicant brought a Rule 43. The parties were married in terms of Islamic law, 3 minor children. The applicant and the minor children left the matrimonial home. The respondent then issued a talaq. Subsequently, the applicant launched the proceedings. The respondent then, for some reason, opposed and raised a point in limine, well, obviously opposed, but for some reason raised a point in limine that the application does not fall within the ambit of Rule 43 because the parties' marriage was dissolved when the talaq was issued. For obvious reasons, the point in limine did not succeed. The court looked at Zafiriu versus Zafiriu. Rule 43 finds application where validity of the marriage is in dispute. And obviously, Section 6 of the Divorce Amendment Act. The Muslim marriage is included as a marriage under the Divorce Act. This matter, incidentally, being decided on 13th of February 2025. Mishak asks, what's a point in limine? It is a preliminary point where a litigant says, look, before we get to the merits of the matter, I want to raise a preliminary point. So before we even look at the finances of the parties in the Rule 43, this matter should not even be before court for XYZ reason. And that is what this respondent said. He said, look, it was a Muslim marriage. I've issued a talaq, so no marriage, no Rule 43. Clearly, Section 6 of the Divorce Act did not feature, of the Divorce Amendment Act at least, did not feature in their thinking. Mishak, incidentally, while I've got you here, thank you for also purchasing the course back. Please just pop your email address where I can send the WeTransfer link so you can also get hold of your bundle, etc., so that I can get it through to you. Right. The point in limine was dismissed. Obviously, the Rule 43 court order was granted. Costs to be costs in the cause. Reasoning of the court, paragraph 12 of the judgment. I disagree with the respondent's counsel submission that the applicant does not meet the definition of the term spouse in Rule 43 and that this court subsequently does not have necessary jurisdiction to hear the application. I'm full agreement with the view expressed by Trollop J in Zafiriu versus Zafiriu. He explained that Rule 43 was merely designed to provide a streamlined and inexpensive procedure for procuring the same interim relief in matrimonial actions as was previously available under the common law in regard to maintenance at costs. Trollop J held that the word spouse in Subrule 1 includes not only, excuse me, blowing all of your speakers out there with that sneeze, includes not only a person admitted to be a spouse, but also one who alleges that he or she is a spouse, even where the allegation is denied. The rule applies whether the validity of the marriage or its subsistence is disputed. So HA versus NA, making it very clear. Excuse me, your sinus is not working with us, as with the technology today. Court making it very clear that in light of the amendments, you still can bring a Rule 43 after a talaq has been issued. Next up, we go to Ex parte EW and others, North Gauteng High Court, Pretoria, Neukircher J. This is a, thank you, Barbara, please, appreciate that. Surrogacy, the confirmation of an agreement with surrogacy before Neukircher J. And Neukircher J, as we know, very, very passionate about surrogacy matters and dealing with a lot of surrogacy matters. What I find interesting in this, don't shut off just because you don't deal with surrogacy. Neukircher J making a lot of interesting points over domicile and jurisdiction based on domicile, folks. And we are seeing this going into the North and South Gauteng High Courts of late. The court's very critical on allegations of domicile, even in undefended and unopposed matters. For those of you following along, page 427 of your bundle, page 19 of your summaries, take note of this judgment if you deal with international matters and specifically international divorces. So what happened here? The first and second applicants brought an application in terms of Section 295 of the Children's Act to confirm a surrogate motherhood surrogacy motherhood agreement that they entered into with a third applicant. Now, remember, folks, these are ex parte applications. This was not argued in an opposed motion kind of way. The issues raised were raised by the court in respect of the papers and after the court had scrutinized the papers. First and second applicant are in a same-sex marriage. They entered into a surrogacy agreement with a third applicant who is the prospective surrogate mother. First and second applicants live in Switzerland, got married in Switzerland, and sought to confirm the surrogate agreement under South African law because Swiss law does not recognize surrogacy agreements. Now, what the court looked at was a whole laundry list of various factors. Section 7 of the Children's Act, ex parte WH and others. Section 295 of the Children's Act. Section 1 of the Domicile Act. Section 3 of the Domicile Act. Section 2 of the Domicile Act. Section 5 of the Domicile Act. Section ILON versus ILON, the onus of proving a domicile of choice. And China Tex Oriental Trading Company versus Erskine, which is the elements of a domicile of choice. The application was dismissed, and the court's reasoning, very, very interesting, paragraph 55 and 56, very pertinent to the issue of domicile. But I'm also of the view that this court cannot confirm the agreement as it does not have the jurisdiction to do so. In my view, neither of the applicants are either domiciled or habitually resident, at least at this stage, within this court's jurisdiction. It is clear that they do not reside within this court's jurisdiction. As stated supra, the Pretoria residence is not intended to be their actual residence, and it is clear that it is simply an address of convenience. In fact, in several paragraphs in their respective affidavits, EW states that he and WG intend to live in Kimberley, are looking for a property in that jurisdiction and intend to live there and temporarily raise any children there. This being so, this court has no jurisdiction to confirm the agreement in terms of Section 2921D of the Act. In addition, I'm not convinced in the papers before me that the application should be granted. There's too much uncertainty surrounding where any children will be raised. It certainly will not be in Pretoria. It may temporarily be in Kimberley, as to remain there permanently would not make economic sense, and future employment opportunities are based in Pretoria, Johannesburg, and in some exceptions, Cape Town. There is also uncertainty surrounding their future employment as in SA. As EW states, with the SA economy being smaller of those of Europe and Asia, and any employment subject to BEE requirements. Thirdly, there is no indication whether their present finances would sustain them in SA were they not to secure employment immediately. WG has no spousal visa, and as at date of the application had yet to apply for one. Although it is stated in the supplementary affidavit that the state process has been commenced, there is a dearth of information regarding precisely what they have done and when. This is an interesting and very succinct judgment regarding domicile, specifically in unopposed matters. And as I said, folks, see the way the wind is blowing. The courts are becoming very critical of domicile allegations and averments. We've seen in our own divorce practice within international matters that the courts are asking for a lot more or requiring a lot more information to establish domicile of choice for foreign nationals who domicile in South Africa, and the retention of domicile of origin for South Africans residing abroad. So if you deal with these matters, do take note of this ex parte EW matter and act accordingly. BMS versus JNW. Before Abro AJ, South Gauteng High Court, page 451 of your bundle and page 20 of your summary for those following along. It's an urgent relocation application, which also deals with the appointment of a parenting coordinator, and this is a local relocation, not an international relocation. As you are aware, international relocations, you deal with Section 18.3c of the Children's Act, 18.3c, Roman numeral 3 and 4 specifically. When it is a local relocation, you deal with Section 31.1 and 2 of the Children's Act. So, the applicant sought urgent leave to relocate to Cape Town. or from Johannesburg to Cape Town with 2 minor children. The application was initially struck off the roll due to lack of urgency. Application was brought again on the urgent family court roll, and at this stage, the children and the applicant had already relocated to Cape Town. The respondent resides in Abu Dhabi and for some reason opposed the relocation. In an order made in June 2024, it was ordered that the children were not to relocate and to be returned to the respondent in Johannesburg. No further provisions were included regarding primary residence, etc. In this instance, the court looked at Section 31 of the Children's Act, major decisions. The applicant's reasons for the relocation were considered. The respondent's grounds for objecting to the relocation were considered. The PC's report and directives were considered. And then our locus classicus, Jackson versus Jackson, was considered. Then Cunningham versus Pretorius. And then finally, last but certainly most paramount, the best interests of the child standard. The relocation was granted, the applicant given leave to relocate to Cape Town. The parties were to identify and appoint a PC, and the previous PC was removed. Paragraph 97 of our judgment, particularly interesting. The increasing number of relocation disputes referred to in psychological and legal literature in South African jurisprudence and that of other jurisdictions is a reflection of the increasing trend of geographical mobility, particularly in relation to work coupled with a higher rate of separation or divorce, after which former partners go their different ways. The reasons for relocating both within and outside of the borders of South Africa are endless: undertaking new employment opportunities, as is the case in this instance, crime and safety, following a new spouse or partner, educational ambitions, or the desire to return home or to rejoin family. That is BMS versus JNW, local relocation before Abro AJ. We're in the final stretch, folks. 3 more to go. We are almost there. TCE versus EE. This is once again before Neukerker J in the North Gauteng High Court, Pretoria. Bundle page 479, summary page 21, and I'm pushing hard to be done before 11, folks, so I'm going to go very quickly. It's an application for removal of legal representation for minor children on the basis that it was believed that the advocate who was appointed for the minor children overstepped their mandate. What was looked at here was also the issue of curator ad litem versus the legal representative and the difference between a curator and a legal representative. So section 28(1)H of the Constitution was looked at, representation of children, the child's right to legal representation, various judgments on legal representative or curator ad litem. Excuse me, again. Excuse me. And excuse me again, 3 in a row. Yo. The longer these roundups become, the more likely it is that funny and odd things will happen, including sneezes getting kicked off and all sorts of sundry. The court looked at the difference between a client-directed legal representative and a best interests legal representative. Very important distinction, folks. Do take note of this. And it looked at the judgment of Legal Aid Board versus R and another. The application to remove the legal representative was dismissed. The advocate appointment as legal representative confirmed, their role adjusted, and there was an appointment of a curator ad litem for one of the minor children. 69 and 70, the court states as follows. In my view, there is place in proceedings for both a curator ad litem and a legal representative to be appointed to and for minor children, but this would depend on the facts of each case. There is no hard and fast rule that can or should be laid down. In proceedings where the children vary vastly in age, such as the present one, it may well not only be prudent but appropriate to appoint both. Here there is an 8-year-old who in my view is too young to truly express his views with any weight. For him it is appropriate that a curator ad litem be appointed to act in his best interests. In this case, the curator ended up having a much broader role to play than simply acting in TJ's best interests. He was tasked with appointing experts, collating evidence, and making a recommendation on the issue of what would be in TJ's best interests. In doing so, his conduct is driven by the best interest principle, and TJ did not and could not give him instructions. Although TJ may express views or wishes, those are simply part of the conspectus of evidence that the curator takes into account when making a recommendation to the court. TCE versus EE, a very interesting judgment, approximately 40 pages judgment by Neukircher J. in the North Gauteng High Court on legal representatives and curators ad litem. 2 more to go, 6 minutes to do it in. So let's see if we can get there before 11. MD versus LN and another. Reasons given by Rossi AJ in the Eastern Cape High Court. And this is page 518 of your judgment and page 22 of your summaries, page 518 of your bundle of judgments. It's an urgent application based on parental alienation for primary care and contact. It's regarding primary residence and contact of 2 children aged 7 and 8 amid allegations of parental alienation by the first respondent. The father sought urgent intervention, claiming that the mother deliberately alienated the children from him, involving them in adult conflict and fostering negative perceptions. The court in December issued a rule nisi calling on the mother to show cause why the FAO's recommendations should not be confirmed, including awarding primary residence to the father. A clinical psychologist named in the judgment as Dr. LaRue conducted assessments and confirmed severe parental alienation, psychological distress in the children, and the mother's failure to cooperate with investigations. The FAO report concurred with Dr. LaRue's findings, recommending urgent intervention as the children were in psychological crisis. The father had had no contact with the children for over 2 years due to alleged interference by mom. Mother opposed the application, denied alienation, and alleged that the father was estranged due to lack of financial support for the children. Now, one wonders how the children would be aware of his lack of financial support. Being 7 and 8, they do not carry the purse. Section 9 of the Children's Act was looked at. Big discussion on parental alienation in this judgment. It is approximately a 25-page judgment. Section 7, best interests, written recommendation by the psychologist and the report from the FAO were discussed, and it's interesting to see the interplay between the two in this judgment. Leave granted in this instance to the first respondent to file a supplementary answering affidavit. The remaining relief by the first respondent, the mother, dismissed. The rule nisi, which was granted in December, was confirmed. So there was urgent intervention in favor of the father. Paragraphs 47 and 54 being our reasoning behind the judgment. The essential one is paragraph 54. 47, you are welcome to read on your own. It is also important to remind ourselves that in cases where a child's welfare is at stake, a court should be slow to determine the facts by way of the usual opposed motion approach. We've seen this before in another judgment. The best interest of the child principle is a flexible standard and should not be approached in a formalistic manner. These principles have guided me in arriving at the conclusions encapsulated in the preceding 2 paragraphs. Paragraphs 52 and 53. Go and have a read. And that was MD versus LN, our parental alienation case this month. Finally, bringing up the rear, F versus F, South Gauteng High Court, Duplessis CJ on the 25th of February 2025. It is an application for the termination of PRR, guardianship, and care specifically. It is on page 543 of your bundle, page 23 of your summaries. The applicant brought an application in terms of section 28(1)(a) of the Children's Act seeking to terminate the respondent's PRR in respect of guardianship, and care in respect to the two minor children. The applicant brought the application on the basis that since their separation, the respondent has not played an active role in the minor children's lives, despite the recommendation of the family advocate for bonding therapy. Very important, this is care and guardianship specifically, and not all PRR, which is distinguishable from our Western Cape judgment earlier. The court looked at Section 7. The court looked at Section 28(1)A, which is our termination provisions in the Children's Act. The court looked at the best interest of the child principle, obviously, Section 9, Section 28(2), etc. The court looked at Section 18 of the Children's Act and the principles of GM versus KI, which said a parent cannot abandon responsibilities and insist on enforcement of rights. Application was granted. The respondent ordered to pay the costs, so the respondent's PRR of care and guardianship terminated. Paragraph 22 of the judgment says the following. For the respondent, this order may be a painful one. It is not meant to erase the role he once had, however limited, nor does it diminish the possibility of personal growth and change. It is simply a recognition that the children deserve stability, certainty, and caregivers who are present not just in name but in action. The door to meaningful reflection remains open to the respondent, and in time, should he engage in a way that aligns with the children's well-being and their needs, there may be different conversations to have. Very interesting judgment on termination. That is F versus F from the Johannesburg High Court. Deborah asked, which court, MD versus LN and another? That was the Eastern Cape High Court in Libera. And thank you for making me have to pronounce that and trying my absolute best to pronounce Libera. You guys, please don't turn me into a meme for that. Right, that was the Family Law Roundup for February 2025. Folks, thank you so much for all of you who stuck around for the duration of the Family Law Roundup. I do appreciate your support. Thank you, especially to our candidate attorney, Atlegang Messi, who assists me in putting together these summaries and who works with me extensively in making sure that these summaries are concise and accurate and useful to you. Once again, for those of you who want to support ThinkLegal, go to our website. You can register for events, join our groups, purchase resources, and view our past webinars. You're also welcome to follow us on YouTube, LinkedIn, and Facebook for more information. As always, ThinkLegal is supported by Vermeulen Attorneys and Lawbox Practice Management Software, both of whom are exceedingly patient with me as I spend exceeding amounts of time or immense amounts of time working on these sessions. So, folks, from my side, I appreciate your sticking around for the Family Law Roundup, February 2025. I wish all of you a wonderful weekend, and I will see you all in WhatsApp land. I will be ending the stream in 5, 4, 3, 2, 1. Go well, everybody. Thank you for watching, and goodbye.